Hello, everybody, and welcome to our new webinar on SB 1159. We did one, I think it was last week or the week before when it first came out, and we told you everything that 1159 said, and now we're getting into the issues and implementation because it's turning out to be kind of a complicated thing. Just by way of introduction, well, first I'm gonna go to the next slide and introduce Pilar first. There you go.
Hi, everybody.
Hello, Pilar.
Hi.
Look how young we look in these pictures. It's ridiculous.
I don't even look like that anymore.
I don't either. I don't have any hair anymore.
It's true. I wouldn't recognize you.
Yeah. I still think we're very attractive people, though.
I think so too.
Yeah.
Yeah. I'd go on
Anyway.
a date with myself.
Well, I'm going to leave it at that. Anyway, so Pilar and I, we're partners and in the law firm. And here's our identifying information if you want to get in touch with us at any point. But just by way of background, we're both partners in Michael Sullivan and Associates. Pilar runs our Fresno office. She's the managing partner there. And I'm the general managing partner of the firm. We have 9 offices all over the state, and we're really proud of it. And we have different sections, including employment and, all kinds of different sections now, not just workers' comp. But I'm also the author of Sullivan on Comp, and this presentation is a production of Sullivan on Comp, not the firm per se, but we are sharing it with the world because the world needs to know about COVID and what to do about all the different laws. This is a Sullivan on Comp production. So you might see at the bottom of the slide some, I don't know, actually, no, I guess you don't. Sometimes we put those SOC sections that pertain to the area but in question, but this is also new. We have a series of webinars that we've already done. This is number 17, I think. We've been doing them since it broke out, and this is Pilar's first guest appearance.
It is. Actually, that's not true. We did one webinar together.
We did?
I forget which one it was. Yeah.
Was it one of the COVIDs?
It was, well, I was just at the tail end. I think Keith was on it and maybe Anthony Culpepper. I don't remember.
Okay. It was a grouping. It was a group.
Yeah, it was a group one. Mm-hmm.
I've got so many of them, my eyes are starting to cross, but
it's okay. I'm forgettable. It's okay.
Thank you. So, but yeah, we've done everything. I mean, we have a book on it, and it comes up in a couple of slides that we're going to show you, but we've covered all the issues in some depth, like a whole hour on when to provide a claim form and liability for TD. When is it work related? There's a lot there, psych injuries, and here's some more. Planning for return to work. We interviewed Jake Jacobs-Meyer, who actually had it and was in a coma for a month, and all kinds of different things. It's available for anyone that wants to watch them on our website, sullivanattorneys.com. And the last one we did was 1159, and when it first came out and what it meant. So this is a follow-up to that one. I also wanted to mention that we have this is the last advertising slide, I promise. We have a book on it. It would be about 200 plus pages if you were to print it out, but it's an ebook and we update it constantly. And we have hundreds and hundreds of people looking at it every day. It's really cool. It's on our website too. You can check it out. It does try to answer every question that you might have about COVID-19 and workers' comp or employment law in California. So it's supposed to be a complete guide for employers. I hope it is. Really proud of it. It's pretty cool. You might want to check it out. One of the things that's in there now, and we may distribute it after this, is FAQs, the facts about COVID-19 and its implementation. That's in the book. You can read it, and it covers a lot of the stuff that Pilar and I are going to be talking about today. What we are talking about today is the Senate bill. So what's happening is I did a big hour-long webinar on it, and I laid it all out, all the 3 different presumptions and what they meant and how they work. And since then, Pilar and I have been talking a lot. We've been talking a lot all over the firm with our clients and each other about how exactly is this going to work. I mean, it's pretty crazy. It's not a simple bill. I would have thought that they could have just said, okay, essential workers get a rebuttable presumption and keep it simple, stupid, right? But no, they did not do that. They've hoisted upon us. There's a big burden now on the employers. It's complicated, and there's 3 different presumptions. And so what we're going to do is compare them and see how they're different and how they work. And then we're going to get into some of the legal issues and the practical issues and especially the reporting requirements for employers and TPAs. Are you ready, Pilar?
So ready.
You look ready.
I'm super ready.
All right, here we go. So we have one slide just reintroducing the concepts. There isn't just one presumption. There's 3 presumptions, and they're different, although they have many of the same characteristics. So the first one is this 86, 87, and 88, which I call them because those are the last numbers on the overall labor code section. So 3212.86 is the one that codifies Governor Newsom's executive order. So it goes all the way through July 5th, 2020. It covers all those. What they did is they codified the presumption and really almost all the language of the Governor Newsom's order, but some of the language is different. Yeah. And then 87 and 88 are for people that worked on or after July 6th, 2020. And there's 2 different presumptions for people after the governor's order, okay? So the one is for frontline workers, and these are cops, firefighters, and healthcare workers. And one is for employees who contract COVID during an outbreak at their workplace.
So everybody else.
Yeah, it's weird because originally I thought, well, they're going to try and cover essential workers, right?
Mm-hmm.
But they didn't. They didn't. They covered some of them. They covered some of the essential workers. And then they said if there's an outbreak, well, this is kind of the catch-all, right? If you're not a cop, firefighter, or healthcare worker, then there's an outbreak, then you get the presumption. But an outbreak, it's just weird, you know? You have to figure out, like, is there an outbreak in your building? And then you get the presumption. I don't know. I mean, it's kind of a weird structure. I don't really see that there's going to be that many outbreaks.
You know, it depends on the number of employees, I guess.
I guess so. And how much we get it.
Yeah.
Yeah. There would be an outbreak at the White House right now.
That's true.
Yeah.
Well, how do you define the White House? Like, what's the building?
Yeah. What is the building? How do you define it? And then how many people actually work there?
Mm-hmm.
Maybe it wouldn't be an outbreak. You gotta have 4%. Right? Maybe that's top secret. Maybe we're not allowed to ask that question. I don't know.
That's true.
But the outbreak one is really burdensome because it establishes reporting requirements for employers and new claims administrators. So, I mean, it's really a pain in the neck. And so we're going to go through like how they're actually implementing it and what the problems are and what our clients are asking us and what we think we should do.
Yeah, I'm excited about that. Clients are asking me questions all the time.
It's
lots
crazy.
of examples.
Yeah, I've been doing this like a good deal of my time has been spent trying to figure this out and then talking to clients about it. And I got to tell you, we only figured out some of it. You know, it's like we only have statutory language, and so we're doing a lot of speculation.
Yeah, we're gonna have to see how it kind of develops.
Mm-hmm.
The case law, I think.
We're gonna do our best.
Yeah.
So there's a lot of things that are the same about these presumptions. One is they're all rebuttable, which is significant because, you know, originally the applicant's attorneys were asking for a conclusive presumption. And also they all say that they're rebuttable by any evidence, which is a lot.
Right.
Right. Yeah.
Right.
Any evidence. Yeah. And in fact, in the last presentation, I was saying, hey, well, that language seems to imply to me that you don't use the evidence code. What do you think about that, Pilar?
I don't know if I agree with that because I think I don't know. I think that when it discusses any evidence, well, you know what? Maybe it would have been particular and said that in line with the evidence code. So you're saying you can use hearsay evidence and.
Well, right now the WCAB, you know, it's up to the judge to determine whether evidence code is used or not, right? Yeah. And usually they let it in and say, well, it'll go to the weight of the evidence counselor, and then they don't use it. Right? So they dodge a recon by doing that.
Right.
But this is any evidence. That's all it says. So
well, then I would probably be saying we should try to use whatever you can objectively point to in good faith.
Yeah,
that's probably the standard. Yeah.
Yeah. And then I note that 88 is different in that it says you can use any evidence, but then it says it includes but is not limited to. evidence in place to reduce the transmission of COVID-19 in the employee's place of employment, and evidence of employees' non-occupational risks of COVID-19 infection. So I don't know why, if it's included but not limited to, they said that. I mean, why bother? You can already use any evidence.
And
So,
that's actually what it says. You can use any evidence. So
yeah,
maybe they're
yeah,
just trying to give you some examples of things that you would use.
yeah.
Yeah, I think so. That's what they were
It's
doing.
weird, but there it is. Okay. And then other things that are the same is that the employee has to test positive or be diagnosed within 14 days. And in a minute, I'll talk about the diagnosis is peculiar to 86, but
Uh-huh.
within 14 days after the day that they worked there, like after they perform labor services at the place of employment at the employer's direction. So that's a lot of different elements, right? But they all are similar in that there has to be a work day where these things happened 14 days before a positive test or diagnosis. So that's the spread. And the reason is, of course, because that is the longest possible latency period in the minds of the experts thus far.
Yeah, that we know so far.
Yeah, yeah. But it can't be at your residence. Like if
Right.
your employment at the employer's direction can't be at your residence. It's a big deal, right? Because that's where everybody is. That's where I am. Where are you?
Yeah, everybody's working from home. Well, I'm in the office.
See, now that's dedication.
But I am social distancing and I try to use my mask, which is evidence you could use to rebut the presumption.
Oh, nice. Yes, I will if you get COVID. And then there's other things that are the same. One is that the whole bill is effective September 17th, 2020. So that's when it all got signed by the governor. And what that means is that, when the governor first issued the emergency order, we thought, oh, maybe the governor is abusing his power. Like he can't do that constitutionally. And so there was a constitutional challenge being raised all the time. And now, though, the legislature has validated it. So there's no more constitutional challenge to the governor's order because it's been codified, right? So, but everything is repealed on January 1st, 2023. And that's significant because when you repeal something, it goes away irrespective of the stage of litigation that it's in, unless there's a final order with appeals exhausted. So, I mean, I can see January 1st, 2023, there being a whole bunch of cases that are at trial or an appeal, and all of a sudden the presumption goes away. And they have to be relitigated. Yeah, that could happen.
I mean, you don't think they're going to come up with something before January 2023 to extend it?
Well, I'm not going to besmirch the attentiveness of our fine legislature in California, which is known the world over for its attention to detail. So you're right, of course, it'll never happen. I even thought of the scenario where this gets repealed and then the governor's order is still there. Right? So now I do have a constitutional challenge again because the governor's order is still there. Right? The governor's order didn't go anywhere. It just got supplemented and stamped.
Yep.
But if you take away the supplemental and stamp, then you still got your order. Anyway.
I kind of hope that situation happens. It'd be interesting.
Yeah, me too. I mean, just as a lawyer, I hope my clients don't hope it because
no, I know it'd be chaotic, but it would be interesting.
Anyway, and the other things that are the same are workers' comp benefits are given, but that's it. Originally they contemplated things like pay for when you are in quarantine. One of the webinars we talked about, there was a case once where a nurse was exposed to people with pneumonia, and then she had to go home for 2 weeks. And she said, "Give me workers' comp benefits because this was from work." And they said, "No, because you didn't get injured. If she had gotten the pneumonia, she could have got the TD."
Yeah.
But, yeah. So there's no quarantine. There's no housing. There's a lot of different things that we're going to be given outside the normal workers' comp benefits and workers' comp. I mean, there's none of that. It's just TD, PD, voucher, death, medical.
Yeah.
That's all you get.
Which I think is good, by the way.
I think so too. I mean, workers' comp's now a century old, and it would have been the first time there would have been a departure from those basic benefits in the history of the system.
Yeah. I don't think a pandemic is a good time to do that.
No. Well, I don't know. I'm just telling you what. Mine is not the reason why. Anyway, the next one that's the same is for all three of them, sick leave, especially provided for COVID cases, has to be used before TTD can be claimed. So, FFCRMA, I think it is where they gave extra leave, federal government.
PFRA.
Yeah, California did too. right? So if there's leave, or there's many companies that have said, okay, you get extra sick days if you have COVID,
Mhm.
but only if you have COVID, So the rule is for all three of the presumptions is that you have to use up all those sick days before you get TTD for all three. And then here's another really interesting thing is the death without dependence unit is ordered not to collect benefits if there's no dependents. So, in a death case, if there's no dependents, the state of California gets still 250,000, right? I think.
Right. It
Yeah.
is.
Right. So, I mean, the death without dependence unit comes and collects their 250,000 if there's no dependents. So you're always scrambling around looking for partial dependents because it's cheaper that way, right? But they're saying, look, if there's no dependents, then the DWB is told not to collect benefits. So there's that. But what's really interesting is if one of the benefits, the presumptions does not apply, then there's no prohibition on them collecting benefits. So if there's a presumption, then the death without dependence unit will not collect benefits. If there's no presumption, they will collect benefits. So they'll be litigating to show that there's no presumption.
That's really interesting.
Yeah, I know.
Well, maybe I think what they're trying to do is encourage on severe cases for the employer to pick it up and pay for the medical costs probably, which will likely exceed the death benefit. I don't know.
Well, even if the employer picks it up, it doesn't mean there's a presumption. That's still an issue of fact.
That's
right?
true. That's true.
Mm-hmm. So the employer can pick it up and then the DWC can come in and say, prove that there's no presumption. DWD, I mean. Yeah.
Yeah.
So anyway, there's things that are different. All three, of course, are different. So the main difference is the first one, 86, the codified governor's order applies to workers on site between March 19th and July 5th, 2020, right? This is a big difference. The other two apply after July 6th. So this is an edifice built on top of the governor's original order. There's other differences. 86, the governor's order before July 5th, has special rules regarding payments of temporary disability. I've gone over them in depth in the past webinars, but fundamentally every 15 days for the first 3 sets of payments, first 6 weeks that is, the doctor has to certify it and produce a report. And it's really interesting because TTD and workers' comp is always being able to be proven retroactively, but these statutes apply that they cannot be proven retroactively. But that will bear some court of appeal stuff, I think, or some litigation.
Yeah, definitely. So you're saying yeah, it is. You're saying a doctor every 15 days has to issue a work status then, declaring someone TTD in order for them to get the benefit.
Yeah, for the first 6 weeks. Yeah.
So if somebody waits for 6 weeks and then gets a report finding them retroactively TTD for those 6 weeks.
Well, if it's under the first presumption, then the 86, then arguably they're not entitled to that TD.
Right. That's crazy.
Yeah, it's crazy. But the other two, no, it doesn't have that presumption. In fact, all three of them waive, I believe all three of them, I meant to look it up before the show, but at least the last two waive the 3-day waiting period.
Right.
Yeah.
I saw that.
Yeah, so that's kind of the same. And then they have different denial periods, right? So, if you have 90 days to deny a claim normally from the time the claim form is filed with the employer, right? Although a lot of people think it's employer knowledge, it isn't. It's when the claim form is filed with the employer. But there's a 30-day denial for 86 and 87. That is the governor's order, codification, and the frontline worker presumptions. They have a 30-day denial period. That's not a lot of time.
No.
That's not a lot of time. We're hearing from our clients all the time, like, how am I supposed to do this?
Right.
Yeah. And so, yeah, I mean, it's hard. But on the other hand, you've got to realize it's all about witness investigation, and a little bit of doctors reporting, who tested positive next to the injured worker at work, and then who tested positive at home in their personal life. And you can do that in 30 days. You just got to be attentive.
Right. And since you could also use evidence at work that you were trying to minimize the risk, it might be enough just to create a good faith basis from which you can rebut the presumption.
That's true. You can always reverse course. Yeah.
It just makes it tough because if the person won't sign a medical release, for example, and won't give you any medicals, how do you get the medicals within 30 days?
You don't. You deny for failure to comply with discovery.
Yeah.
just like we always do when they do stuff like that. Yeah. And of course, like the $10,000 of medical treatment before denial is still part of the game, right? So until the denial issues, you're paying, which is not as
Right.
significant if someone's in a freaking coma,
Mm-hmm.
but it's only up to $10,000. So I don't know. Anyway, and then uh, 88, the last one, the outbreak presumption, has 45 days to deny. So I guess they thought that we need a little bit more time to figure out if there's an outbreak, which I guess makes sense because you have to figure out like how many people worked at a place at a given time. There's an extra layer of discovery. So they have 45 days. So, I mean, this is the first time in the century of workers' comp that we've had a truncated denial period.
Really?
Yep.
It's always been 90 days. Wow.
Always been 90 days. Yeah. I mean, unless I'm wrong, and I don't think I am. It's like, man.
You're never wrong.
No, that is, well, this is true. This is what we tell the world.
Yeah.
Is an internal rule at Michael Sullivan and Associates that if it's a good idea, it was mine, and if it's a wrong idea, it was Pilar's.
It's actually usually correct.
Anyway, so then another difference is that 86 all three of them require a positive test. Okay, it's a quid pro quo for the presumption. You got to show a positive test, otherwise there is no presumption. The only one exception is the first presumption, the 86, the governor's order codified, which also allows for a diagnosis, but the diagnosis has to be backed up by a positive test. And this is interesting too, because there's this difference for antibody tests. There's two different types of tests, right, that you can do. There's serologic or antibody tests, and those show, what do they show, Pilar?
I think that it was in your system at one point.
You had it already.
I think it's a blood test.
Yeah, you had it already. It shows that you had it at some point. Doesn't necessarily show if you currently have it though, right?
It doesn't.
It doesn't. The other kind of test, non-serologic, non-antibody test is, I learned this when I was putting together, I read the statute. I probably should have known it ahead of time, but polymerase chain reaction, PCR, that's the one where they see if you actually have it. I'm pretty sure that's the one where they stick it right up your nose.
I read an article the other day, this is totally a tangent, where some people were alleging they got brain damage from the nasal swab.
Nice.
It like went too far up their nose. Anyway.
Someone like that, you got to ask, how smart were you really to start with? So anyway.
Hey, I have a quick question, because this comes up a lot with my clients. So it requires a positive test, but what are your thoughts on whether the employee has to show you the actual positive test? Can they just tell you they tested positive?
Yeah, that's a good question. For the presumption to apply, they're going to have to show a positive test if they want the presumption to apply. Now, if there's a whole world about, we'll talk more about it at the end, I think, but there's a whole world about like OSHA requirements for investigation. When someone has COVID, you have to investigate to see if it's work related, right? So I think you can certainly ask them for the test. And there is the obligation to investigate when an employer becomes aware that someone they know that someone has a work-related injury, they have to provide a claim form, right? And that's a whole nother area. And we're going to talk about those in our next webinar, which we're going to do next week with Eric, and talk about the interlacing between OSHA, AB 685, and the notice requirements there, and the obligations of workers' comp. So we can get it really laid out straight for the employers and what their obligations are. But I think the answer is you can ask for it. I don't know if anything in the law that allows you to demand medical information. Now, look, if you're in a litigation environment, you can certainly subpoena it.
Right.
You can certainly take depositions and ask under oath, and they probably have to answer that. You can demand production of documents, right? So yeah, I think in a litigation environment, yeah, you can.
Yeah.
Pre-litigation, you can ask, and you probably should ask. How's that sound?
I like it. Makes sense.
Okay. So anyway, so the 86 actually is different because it allows for antibody tests, but 87 and 88, the post July 6th ones, they say it's invalid. That's not a positive test. It's not a serologic test. Is invalid. You got to have up your nose with the PCR. Otherwise, you don't get it. So there's different types of tests that are required depending on the type of presumption you're looking at. Other things that are, this is really far out. I'd like to know what you think about this, Pilar. But
Okay.
this is one thing that it says explicitly in every single presumption. Because look, okay, let's say you get infected by COVID. Is that a specific date of injury or is that a CT? What is it? What is it? And when did you get it? Because look, I mean, it says you have to have a positive test within 14 days of working. Now, let's say someone has a positive, someone works up until July 10th and has a positive test on July 12th. Well, really, there's two possible presumptions that could apply, right? Because they did work within 14 days for both 86 and well, actually all three of them could apply. Well, no, because you can't have the last two apply at the same time. Either you're a frontline worker or you're an outbreak, or you're an outbreak. Right. Okay. But anyway, you see my point is like, okay, so how are we going to deal with this overlap of dates and what is the date of injury? Well, they seem to try and solve that problem by saying the date of injury shall be the last date the employee performed labor or services at the place of employment. So they say, okay, it's the last day you worked. That's the date of injury. And so you can't have more than one presumption applying, right? If you worked past July 6th, then the first 86 presumption can't apply. So that's interesting, right?
I think it's good because it accounts for how little we know about the transmission. I mean, we understand that it's airborne and masks help prevent it and things like that, but you know, absent somebody like sneezing into your mouth and being able to pinpoint like that exact situation that occurred, you're really just around people and exposed. So I think the fact that they said, okay, we're just going to choose this date is helpful.
It doesn't really change the obligation to do your investigation, and it doesn't change the standard of proof for, you know, showing exposure to the disease, right? I mean, you still have to do that investigation and see like how that happened to the injured worker. Where did it happen? But the date of injury, if it's established, that's going to be that last date of employment. And then 87 and 88 add this language prior to the positive test, which means that it has to be on the last date of employment prior to the positive test. So if you have a positive test and you keep working, right? I think that's what that addresses. So if you have a positive test and you keep working, the date of injury is before. It's like probably the day before you got the test.
It also accounts for the latency that at least previously they were experiencing between the test date and when you would actually get your results, I think.
Yeah, I find this kind of confusing a little bit, but I think this is the only reason I could think that they put this language in. I mean, what about, I have a hard time visualizing someone getting a positive test and keep working.
It's because of what I'm telling you, the latency period. You could get tested on Friday and not get your results till the following Friday.
I see.
So the question is, if you got tested, should you have just stopped working because you felt the need to get tested until you got the result, or I don't know.
It uses the language prior to the positive test. Does that mean prior to the testing or prior to the results? I would guess.
Well, positive test would be the results, right? Because you have to know it. Well, I
don't know. I mean, I was thinking maybe it would be the date of the test because that was when it's the test
date
is the noun, right?
Yep.
Positive is adjective.
Yeah, I think you're right. I think it's the date of the test.
Yeah. So it makes a big difference, though. It could make a difference for coverage. It could make a difference for which presumption applies.
Right.
You know, and the standards are a little bit different. And then there's like, you're getting a fight over TD because you didn't produce the doctor's report. It's like, oh, well, actually I mean, it's crazy. Yeah. So, I mean, anyway, the date of injury should be the last date the employee performed labor or services at the direction of the employer at the place of employment prior to the positive test. So I guess it could be the same day as a test or the day before the test, depending on if the employee worked there.
Yeah, because you could also foresee a situation where they take one day off, they don't get better, and then they go get the test. Like there could be some gap.
Yeah. This also makes it different under Labor Code 5412, which is the well-known statute that defines a continuous trauma claim as the first concurrence of knowledge and disability. And this is often the key statute when two carriers fight over exposure, right? But now we don't have a CT. We have a specific date of injury. So this coverage, July 6th date, I mean, maybe it's not going to be that big of an issue because, I mean, how many coverages end on July 5th? I don't know. But it could be after too. I mean, I don't know. I mean,
a lot of fiscal years. Well, maybe July 1st.
Yeah. So it might really matter whether it's when the test occurred or when you got the results.
Yeah,
It could
I
put
think
it all on one carrier or another.
Yep.
I have a feeling there will be a few cases where that is hard fought.
Yeah, I think so too. It won't be the norm though. It's kind of very specific.
Yeah, I don't see there being that many like that. I agree with you on that. But they're, you know, it's our job to sit here and think of these weird little things, which is what we're doing.
I think of weird things all the time.
Yeah, that's really, I think the world needs to know about that, Pilar. Really, none of us.
Oh,
I'm
I
not
should
really
say
qualified to
creative
help
ways
you.
of handling compensation claims.
Right. Anyway, I wanted to cover a few issues for frontline workers because a lot of inquiries are being made as to, okay, who counts as a frontline worker, right? And healthcare workers in particular it's kind of a big deal on that. So anyway, the first group is active firefighters. I don't get a lot of questions on that. It lays it out pretty clearly, all the different types of firefighters, city, county, it's just, it's a lot. It seems to fall at volunteers, partially or fully paid, right?
Mm-hmm.
Department of Forestry, active fire for the U.S. Department of Defense. So it covers a lot. It's pretty aggressive. And even NASA, the Federal Aviation Administration. I mean, they're covering some firefighters here. And then there's cops. And, we're going to have a slide on cops because, oh my gosh, it references multiple sections of the penal code as to what cops are in and what cops are out. And it's really a lot. And it's beyond the scope of what we're doing, but it is in our book.
Great.
So if you want to know if your cop fits in there, then go to the book and look at it. Really long, and FAQs too. It's a really long answer. So, and then healthcare workers is another area. So there's a whole series of different bullet points in the statute which identify when healthcare workers can be considered frontline workers for purposes of the presumption. One of them said, and we've done some exploring here with some of our clients that are health providers.
Right.
Yeah. So one is an employee who provides direct patient care, right? So if an employee provides direct patient care, or as a custodial employee in contact with COVID-19 patients that works at a health facility. Now, if they provide health, that term works at a health facility applies to both situations. This is it's not too many, custodial workers coming up in the issues, but people providing direct patient care? What does it mean to work at a healthcare facility? Because if you provide direct patient care, but you don't work at a health facility, then you don't get the presumption, unless you fit into one of the other categories, which I'll show below, like a nurse or EMT.
Yeah, so tell us.
I'm going to tell you what it means to be in a health facility. Are you ready?
I'm ready.
Okay. Well, you look it up. It's in Health and Safety Code 1250 ABC MRN. And A sort of lays out the groundwork, which is, it says it's a facility, place, or building. So when I first read that, I'm like, oh, it could be any place. So your school nurse could be in her little place and is organized, maintained, and operated, right? Okay. What you do, it's like, that's what you do there. And then for the diagnosis, care, prevention, and treatment of human illness, or for one or more. Okay, very broad still. And then we get to the kicker, which says that people are admitted there for a 24-hour stay or longer.
I don't think that's schools.
No, it limits it a great deal, right?
Right.
It's
hospitals, basically.
It's a hospital. Yeah, it's a hospital. The subsections of 1250 BC M and N talk about psychiatric hospitals, nursing facilities, hospices, right? But it's really a place you go where you're spending the night because you're pretty screwed up.
That really limits it. So no doctor's offices?
I don't think so. What's
That's
really funny though is that nurses, and I don't know if I have it in the next slide, it's 2 slides down, but nurses, EMTs, right? They get it automatically, but doctors don't. So you go into a doctor's office and the nurse would get it, that's the presumption, but the doctor would not. How you like that?
It's crazy. I mean, look, nurses are generally more frequently in contact with the patients, I think.
Yeah, that's true.
So it makes sense in that respect, but the doctors are still exposed.
Mm-hmm.
They're at an equal risk, I think.
Oh, remember, that's just direct patient care is just one of them. There's another one here that I just switched to, which is employees of healthcare facilities other than those described in paragraph 7. So these would be employees at the health care facilities that we just described at the hospital who don't provide custodial care or direct care. So hospital administrators, anyone else in the hospital. It says that the presumption would not apply to them if see how complicated they made this thing?
Yeah.
Why did they do it? I don't know. Why did they just say cops, nurses, healthcare workers? I mean, it just doesn't have to be like this. But, two things you don't want to watch being made, right? Sausages and laws. You've heard this, I'm sure.
I have not.
You haven't heard that? Man, I can't believe you got through law school and didn't hear that. Yeah, it's ugly. Anyway, so it says the presumption doesn't apply if the employer can establish that the employee did not have contact with the health facility patient within the last 14 days who tested positive. How are you going to do that? How are you going to establish that if the employer has to establish they didn't have contact with the COVID person?
Yeah, that goes back to that proving a negative. It's tough to do.
Yeah, I mean, going back to it, it's like direct patient care. So that would be doctors and nurses, and then this talks about custodians. But maybe if there was a doctor who is an administrator would fall into this category, and that doctor would have an easier time of it than a doctor who actually provided direct patient care.
Yeah, that's crazy.
Yeah, that is crazy. And then of course there's the other ones. Like if you're an authorized registered nurse or an EMT, you get the presumption. And like I just said, they get it irrespective of whether they're at a healthcare facility. So I presume that means that you're a nurse working as a nurse. I mean, if you're a nurse and you're working as a library because you just hate nursing. Yeah. Yeah, I would think, but I don't know. And then it says an employee who provides direct patient care for a home health agency under Health and Safety Code 1727. And we looked that one up too, didn't we?
Yes, we did.
Yeah. So any organization really which provides nursing services or home health aides to people in their homes. So if like you're an agency that dispatches nurses and you're one of the people that provides direct care, even if you're not a nurse, if you're going to someone's house, then you get it. You get the presumption, right? No, not the doctors, right?
Well, what's interesting too is that they included EMTs or paramedics. Not that they shouldn't have, but I don't see a lot of people going to the hospital for, I don't know, but I don't see them going to the hospital via ambulance. It's usually a slow progression.
Yeah, that's true. I mean, they could have an episode at home and the 911 gets called. I guess that must have been the idea behind it.
Yeah, but then to specifically not include doctors.
I don't know. They don't have to actually provide direct patient care under this condition.
Right.
So there's that. They just have to be working as, this did in this job, and then they get a presumption if they get COVID. So, one thing that came up with student nurses too. There's a lot of student nurses in educational environments, and these nurses are often employees, and like a school district will vote to make them employees rather than volunteers, because that way they are covered by workers' comp and they're not able to sue the school district for civil court for civil liability. But by virtue of that, they become employees, but they're not registered nurses, right?
Right.
So they would go back to the providing direct care at a healthcare facility or one of these other categories. Yeah. And then we have provider of in-home support services. Like we represent IHSS a lot,
Right.
and we see that all the time. People taking care of themselves, but it also says that when he or she provides services outside his or her own home or residence, that's a very limiting factor because most people I know that are providing in-home supportive services are doing it for family members.
Yeah, but it's often at the family member's house, not necessarily their own house.
Yeah, that's true. I guess if they don't live together, they often
Yeah.
do live together. They
They
often
do.
Yeah, I'd say most of the time. But you're right. That's a good point. Like if they live somewhere else, then they're providing it outside their own home or residence. So if they're going over to mom's house every day to provide care and get paid by DSS, they get it. If they're living with mom, they don't get it. Does that make any sense to you? I wonder why they did that.
Well, maybe because it's if you also live there, it's kind of speculative. Like you would have gotten it anyway, you know?
Yeah, I was thinking that too. Maybe they think that's more personal in nature.
Yeah.
They
Or
want
maybe
to
they're
really.
just trying to get people to move out from their parents' house.
Maybe the parents want to be weighed in. Like, I want my 35 son out of my
Can you
house.
add this to the Senate bill, please? I've been trying to get my son out of the house for years.
I didn't watch. And then we go to the worst one of all, which is the hardest one of all, which is the workplace outbreak presumption. So if you're not a frontline worker and you're out from July 6th, then you get the presumption for the workplace outbreak as long as there's an outbreak at work and you have a positive test. So the conditions are they have the 14 days after the day they last worked there. It's after July 6th. And then here's the two key terms. It has to occur during a period of outbreak, and I even bolded, and I don't bold in my presentations, but I did here, because positive tests occurred during an outbreak at his or her specific place of employment, which is probably the 4 words which are the most confusing
Yes.
to employers, especially because there's obligations of reporting positive testing and the population within specific places of employment on a regular basis, which has had us all scrambling for the last 2 weeks.
Right.
So again, the specific place of employment is not the employee's home or residence, unless he or she provides home health care services to another individual at his or her home or residence. So I like that. So that's different than what we just talked about, right? So it could be at your own home if you're providing home health care services to another individual at his or her home or residence, if this presumption is being sought.
Okay, so if you're no longer under 87, so if you're a worker under 88.
Yeah.
Okay.
Yeah. If you're a worker under 88, then your specific place of employment could be that home. But it's always going to be at least 4 people that have to have it for an outbreak. So when the hell would this even happen? It's like, are we at home with like more than 4 people providing home health care? You know, I mean, where exactly are you living?
It's not impossible though.
It's not impossible, but
yeah,
and you have to be providing service to another individual. Yeah, yeah. So that's weird. I mean, it's really complicated. It's a lot of little detail strands that you can get wrong here. So anyway, those are the basic conditions. And of course, the discussion for us is going to center around this outbreak and specific place of employment, because that's what our clients are trying to understand, and particularly with the reporting requirements. So what is a specific place of employment? Well, there's literal language in the statute, and that is all we have. That's it. It's the literal language of the statute. We don't know what this is other than that. And it says it means a building, a store, a facility, or agricultural field where the employer performs work and at the employer's direction. So, UCLA. What is a specific place of employment?
Lots of buildings, lots of stores, and lots of facilities.
Yeah.
You know, Yeah,
Well,
go for it.
Okay, yeah. To me, it's like, well, you can argue, it says or. So is there an element of employer discretion there? I mean, can the employer decide, well, the South Campus is one facility and the North Campus is another, or it's actually every single separate building?
Well, it also says the,
Yeah.
which implies that you have to kind of choose one, in my mind. Um,
The advice I'm giving and what I'm seeing mostly coming out of the conclusions of the confabulations between the TPAs and employers is the word building is in there for a reason, right?
Mhm.
So it's like, yeah, it could be a facility, but if there's multiple buildings, you have to count it by you should count it by building.
I
Now,
agree. They could have made it plural if they
yeah,
wanted to,
right, right.
but they didn't.
But it's arguable, man. I mean, it's not by any means super clear.
Mm-mm.
It's not obvious what this how this is supposed to work. And then is it better for an employer to characterize it as a campus or a facility or an address as opposed to each individual building in that place? Is that better for the employer?
It can be because it might make it more difficult to meet the 4% threshold.
Mm-hmm. Yeah.
Uh, but then you're also widening the net for potential COVID cases at that specific place of employment.
Right. I put it a couple slides down, but you either have to have 4 people if there's under 100 people at the specific place of employment, or 4% if there's more than 100 people at the specific place of employment. So if you have just the building, you're unlikely to have more than 100 people, right? So but you have to have at least 4. So the smaller the number of employees, the less chance there'll be an outbreak.
Mm-hmm.
But on the other hand, keeping track of who's in a given building at a given time is freaking impossible.
Yeah. Like,
So
what if you have to go between buildings?
yeah. Well, there's this other rule here that says if the employee performs multiple places of employment within 14 days of the positive test, then you have to determine the existence of an outbreak for each of those places of employment. So if you have an employee going around to different buildings, what about like UPS?
Oh no.
Delivery service.
They're too complicated.
Well, I mean, they go to everybody's house all the time.
Right.
Is it a place of employment?
I don't think so. I don't know what your thoughts are.
I don't think so either. I can't see how that could possibly be a reason. It seems like with the language building store facility or agricultural field, it sounds like something owned by the employer. It's like a regular
Yeah.
place of work where employees gather, right?
Right.
Rather than everywhere you go in the world. And
Right.
plus, everywhere you go in the world is impossible to track. So if I'm a delivery service, I'm just going to risk it all and not report on the everywhere everyone goes every day
I agree
because
with that.
it's
I don't think
impossible.
that was the intention behind this. I think what they wanted employers to do was make their best effort to break down the entire employment into buildings, like individual buildings, and try to identify the primary place where the person worked. And if you identify more than one place, then make that specific assessment for each employee.
But the thing is, how do you track how many people are in a building, and what does it mean that they're working there? I mean, if I walk by and say hi to my friend Sue for 5 minutes in the other building, am I now an employee in the building on that day, such that we know how many people work there?
Well, I think what they asked for, right, is the maximum number of employees that could have worked at that specific place of employment on that day, right?
Mm-hmm.
So your maximum is always going to be your total number of employees. I don't know.
Yeah.
That might be
Well,
like
how do
the
you track
easiest.
that? How do you possibly track that if you're an employer? Do you have to set up scanners in front of every building?
Yeah, we should start that.
Yeah. And then like I thought about the personal comfort doctrine, which says that if you're kind of doing anything on an employee's
Mhm.
premises that's work and you get injured, it's work related.
Yeah.
So that would tend to make me think that anybody that actually is an employee that goes into a building on a given day would count. And I don't know if it's possible to track that. I just don't know if it's possible. And the applicant's attorneys are going to say, well, you didn't accurately track it, so I get the presumption.
Right.
Mm-hmm. And then the other big issue is what's an outbreak? So, I mean, it's like I said, if there's less than 100 people at a specific place of employment, then it's 4 people. And if it's over 100, it's 4%. Or if they're shut down by the Department of Public Health, which hopefully will be a very rare instance.
Right.
Yeah, I mean, I don't know how you track that. People in and out the
they're
building.
kind of leaving it up to who's determining if the outbreak exists? Is it the employer?
No, it's a TPA. Yeah. So what happens is the way it works, and I think I have it in the next few slides is,
Sorry.
yeah, actually at the very end. So, well, let's just keep going through it and
Yeah,
it'll come
sure.
out. So what's an employee? How about that? One of the rules, it says that this presumption only applies to employers that have 5 or more employees. Okay. Now it's easy to get confused there because then this is a threshold question for whether or not the outbreak presumption even applies. You got to have at least 5 employees in your whole organization, right? So it's not about how many buildings or 4 people or anything like that. That's a threshold question. There are 5 or more employees. And so, you know, it's probably pretty rare that you'd see an outbreak in a company. You have to have at least 4 people, right? So how would you almost, it's kind of a non-issue, right? Because if you don't have at least 5 employees, it's like that. But, you know, no independent contractors, no volunteers, no student teachers, no visitors, they don't count, right, for reporting requirements. And should include part-time, temporary, substitutes. These are employees.
Right.
Right. Remember, this is not just about jurisdiction of the workers' comp claim, but counting the number of employees in a specific place of employment. What about general special employers?
Yeah, you know, I get this question a lot from some clients that they're either general contractors, they work with a lot of subcontractors. So they have that special employment relationship, or temp agencies that are sending their employees to various client locations to perform services. Who does the reporting? How are they defining, you know, who are they the employee of?
Right.
And it was a good time. Yeah, go.
The general rule is that if someone tests positive, you have to show for the prior 2 weeks, and we'll get into it a little bit more in a couple of slides, but you have to tell the TPA, if you're the employer, right? You got to tell them not only about the existence of a positive test, but you also have to tell them who in the prior 2 weeks worked in a specific place of employment.
Correct.
So, you know, how do you track every single employee in every single building? You know, that's going to be the hard part.
You know, especially for the general and special employers. I think they're going to have to get a system going where they're at least understanding what the maximum number of employees might be at any given site on any given day, if they have any chance of being able to implement this in a way that's doable, because there's a very short period to do the reporting.
Yeah, so like let's say we take a temp agency, for example, right? So I hire Pilar as a temporary typist in my Fresno office.
Okay.
Okay, and I hire it from Temp Agency Inc. Now, under the law, like in a workers' comp law, you're an employee of both, right? So if Temp Agency Inc. doesn't have insurance, then I got to pay.
Right.
My workers' comp coverage comes in, right? So that's like a well-known, you know, we have pages and pages on that in Sullivan Comp about those kinds of disputes. Or vice versa. If it's on me to pay and I don't have it, then the general contractor's got to pay, right? So it's like if I'm the general contractor, if I'm the temp agency, then I look at, and you test positive for COVID. Well, now that specific place of employment, you know, I need to go to Michael Sullivan and Associates and figure out how many people work there on the days in question, because I don't know.
Yeah, I think
there's
you
probably
do.
something in the contract between general and special employers which mandates cooperation between the two entities for purposes of workers' comp. So I don't see us having a hard time telling them about numbers. We'd probably have to do that, or they could use discovery devices to get it from us. So there's that, right? And then, so if I'm the general agency, I report the fact that there's an employee who tested positive, and here's the number of people in that facility for that day. And then if I'm Michael Sullivan and Associates, and then the temp agency, they normally cover the workers' comp, right? The temp agency does. But then it's on me now to report it and to, in fact, since we're both employers, I think we both have to do the reporting, even if there's no claim, right? Because the reporting exists independent of any actual claim. So that means that both the general and the specific employer have to independently
report to their carriers.
Report, yeah, I think so.
Or their TPAs. Yep.
Yeah, I think so. That's what I think.
But only one is reporting it as their, well, no, both would be reporting it as their employee, but only one would be reporting it potentially as industrial.
Right. And here's the rule. The employer has to report to the claims administrator when it knows or reasonably should know, right, that employee has tested positive for COVID-19, and they have to do it by email or fax within 3 business days. So every employer's got to do this.
Yeah.
Now, this is tricky. What does it mean that an employer, and you have to remember, you got to report it to the claims administrator irrespective of whether there's a claim or not. This is something you do, right, whether a claim exists or not.
Correct.
And it's like, how often is there even gonna even be an outbreak? So what is this? Why are we having to do this? I mean, I worked with some clients, and like, it was a news article on Work Comp Central this morning. Cedric set up a portal, and most of the TPAs have. So the employers just go in there and type, okay, there's a positive report, and this is the number of people at the locations, locations where that person worked over the prior 2 weeks. So, I mean, that's what you have to do before there's any concept of a workers' comp claim. What does it mean, though, to know or reasonably should know that there's a positive COVID test?
Yeah, that goes back to the earlier question. If someone just tells you that they had a positive test, does that impute without showing it to you? It might not create enough evidence to meet the presumption, but is it enough to require you to report?
Well, remember, you don't have to tell them all the locations. I'm sorry, I accidentally switched the slide here. You don't have to test all the locations. You don't have to report on all the population in the various locations unless you have a positive test, right? So you don't want a positive test, because then you have to go figure out how many people are each location Joel's reporting. What does it mean to reasonably should know that there's a test? I'm positive test. I don't really know the answer to that. I mean, if someone comes up and says, I have COVID, I had a positive test. Well, you may not have seen the test, but you know reasonably that there's a test. Right. And probably it'll come out during the OSHA investigation. If you make inquiry, they're going to tell you. So it's probably not that much of an issue. But, and then this is all the things they have to report, that the employee tested positive. Now, you're not allowed to say who it is unless there's a workers' comp claim. The date they tested positive, the date the specimen was collected for testing. That's interesting here, isn't it? Because they're making the distinction between the date they tested positive and the date their specimen was collected, which goes to our previous discussion about when does that was performed, right? So that may inform that discussion.
Right. So maybe the date of the testing positive is the date you get the positive result, because it's different than the date the specimen was collected.
Yeah. And I see I made a misstatement. I said it's 2 weeks before, but it's actually the 45-day period preceding the last day the employee worked at each place. So it's 45 days before. You got to tell them for each of those 45 days, you know. Yeah. And the address for each address.
This seems impossible to do within 3 days. I wonder why they only gave the employers 3 days. I mean, I don't know. It's just crazy.
Well, no, you have 3 days to report the positive test. Right.
But you're saying all this additional information.
I think this probably does fall within the 3 days. You have to do the address.
That's how I read it.
Yeah. Okay. Probably is true. Yeah. The address of the employee's specific place of employment during the 14 days. That's why I said 14 days. It's all the addresses where they worked in the 14 days prior to the positive test. But then you have to say the highest number of employees that worked at the specific place in the 45-day period preceding the last day they worked at each place. So, yeah. I mean, they want more. It's weird because they want to know the numbers for more than the 14-day period when the exposed person may not have even worked there. That's a lot of information. I mean,
especially to gather in 3 days.
Yeah, it says the highest number of employees that worked at the employee's specific place of employment. Okay, so you don't have to do every day. You have to have the highest number.
Yeah. I think they're better off just assessing their total number of employees and consistently saying that was the highest number of employees.
It's an issue of fact, though. I can see applicants' attorneys going after this, saying we did it wrong, cross-examining employers.
They're going to do that anyway, so.
Yeah.
I
put here, I have a slide here on how the heck can we do this, We're a little bit ahead of some of these slides, but the TPA is all portal, so you put in the date of the test, when it was sample was taken, all the specific places of employment in the 14 days prior, the highest number of employees 45 days prior. I mean, there's privacy concerns I have down here on the list. In particular, you're not allowed to, and we've already seen this just in terms of employment law stuff, but you're not allowed to tell people who has COVID. Right. So at work, if you say, hey, someone had COVID in your area, you can say that, but you can't say who it is, even though probably everyone knows who it is, but you can't do that. The question was raised, like, what happens after that? So when you report it to the TPA, you just say there is a positive test. That's all you say. You don't say who it is. You don't identify them. But when someone actually files a claim, all bets are off. There's no special protection like there is for HIV in this law. Like there's no privacy protections for COVID patients in the law. So then all the information comes out. I added here that we talked a little bit about how OSHA requires an investigation, so that probably will help with determining whether there's a positive test. Payroll services may be of help, because you can tell how many employees you have on a given day, right? But they don't help with buildings, I don't think.
No.
Yeah.
Definitely not.
Maybe. Yeah. And then I had a line here. Why don't we just give it up? Like, what if we just accepted all the claims? Then would we still have to report like this?
I think you still have to do the reporting.
I think you're right. Yeah, that's not a way around the reporting, just to say we're going to accept all the claims, because we're still the statute still requires it independent. It's like, well, we can say, well, look, I mean, I'm accepting all the claims, so the presumption doesn't matter anymore. But it's not the way the statute's worded. It says you have to do this, right? Otherwise, you get a fine. Now, maybe they won't fine you if you do that. I don't know, but I don't think it's a foolproof way to avoid this reporting requirement. And maybe at some point it's stupid, you just you're gonna have to make a judgment at some point as to how many people work there. Like if you have a building and only 30 people work there, and you know that maybe 3 people come in a day from other places, you can pick a number that's under 100.
Right.
You're probably gonna be fine. As long as you err on the side of caution, you're fine. It's only probably gonna be an issue when it gets down to the wire. So anyway, that's pretty crazy. Another aspect that's pretty crazy is that you have to do it retroactively. So it says that any employer who's aware of an employee testing positive on or after July 6th, and prior to the effective date of the statute, that's September 17th, has to report that required information within 30 business days. So all the employers on September 17th, they go, oh man, I have to go back and see how many people were positive after July 6th, and then do all the reporting. Which is a real bummer because you didn't have any notice that you had to start counting people in buildings. So how can you possibly go back in time and count them all?
Yeah, a lot of employers were keeping track of this stuff anyway. But I mean, at least they give you 30 days and not 3 days.
Yeah, that's nice. That's October 16th or something like that.
Yeah, 16th.
30 days. It's 30 days in September, right? Yeah. I'll have to get the wheel out, the date wheel. Yeah. So this is another real burden for the defense. And finally, we have this slide on claims administrators. I mean, the thing about it is, for claims administrators, is a burden too. They're not getting paid for this. I mean, this is not work. This is not work on a file. So they got to have like every single account, right? They got to have their employer rep communicate with their client, train them on how to use their portal after they have their IT crew create the portals and make sure it's workable, because they're the ones that have to determine whether there's an outbreak.
Right.
Yeah.
At least they made it somewhat manageable by just establishing a 4% threshold. So really they just have to see if that percentage is met, but it's not easy because you're having to sparse out specific places of employment, number of employees. It's a lot of math.
That's right. So depending on how the portal is set up, they could be, I mean, they have to predetermine. I had it in the prior slide, I didn't talk about it, but you have to predetermine like what buildings are specific places of employment and what aren't for each employer. They're gonna have to help the employer figure that out, and then have to channel that information, and then they're responsible for determining whether there's an outbreak, not the employer. So this is work off the files, right? This is not, like I said, they're not getting paid for this. It's a big burden on the TPAs for sure.
I can see the TPAs picking someone to work just on this.
Oh, I think so. I think what they probably do is there's an account rep for each employer, and that account rep has got to interface, and there's got to be the IT guys who set up the software that allows the account rep to educate and discuss with the employers and make it all streamlined. I've done this with a couple of clients. I've been part of it. And training the employers, like figuring it out together, like how's this going to work? And it's not pretty. I mean, because we're all scratching our heads, going, what do these terms even mean? I mean, so just in this presentation today, you can see it's like a whole lot of different stuff that could be wrong or could be off, or we're making judgments.
Right.
So, yeah. And then I thought this language was kind of intellectually stimulating. It says a claim is not part of an outbreak during a continuous 14-day period where the requisite number of positive tests have not been met. So, and then it says the claims administrator has to continually evaluate each claim to determine whether the requisite number of positive tests have occurred during the surrounding 14-day periods. So if it's a continuous 14-day period, I guess it's 14 days on either side.
Yeah. So you're really looking at a whole month.
Yeah, 28 days, really. You have to look, and then they have to like keep track of all the positive tests and keep track of the maximum number of employees. So if you get a positive test, you got to look back for 14 days. How many other positive tests were there? And then that actually might change whether there's an outbreak for the prior positive tests. Right? Yeah, it will. Yeah, because it'll add up. But they can also fall off. And so the analysis has to be done every day, both prior to and before for each and every positive outbreak to determine when there's an outbreak. Now, that doesn't mean there's any claims.
Correct.
Right? But they have to do this. If there is a claim, they have to do this analysis to figure out if there's an outbreak during that time period.
They should have given them a 30 or at least a 28-day reporting.
Well, they did it. Well, it adds up to 28 days when you look at it, but it's just a continuing change every single day, comparing the number. And you only have to give them the maximum number of employees in the place 45 days ahead of time, but you're going to need to know on a given day how many people employees are there on a given day. Yeah, in order to compare every day the number of employees versus the number of positive tests in order to make that determination. So, I mean, I would think that the TPAs would have to ask the employers for every day. I mean, when you first do the reporting, you just have to list the specific places of employment and then the maximum number of employees in the prior 45 days. But when you're doing this analysis and you're the claims administrator, you're going to need further inquiry, more than just what goes into the initial portal reporting, and say, okay, how many people were at this? And so, I mean, you're going to actually need to know if it's under 100, it's a threshold question. And then if it's over 100, how many? See if there's 4%. I mean, if you had more than 4 people in a given day, you'd need to start knowing if there was more than 100 on that particular place of employment, specific place of employment. Yeah. So further inquiry is going to need to be made whenever there's a positive test, I think, beyond the initial reporting on the portal, because, but maybe only if there's a claim filed though, right? Because otherwise, you don't have to determine if there's an outbreak or not. What difference does it make? There's no presumption to be applied.
That's true.
Yeah. So
and it does reference each claim. It
does, yeah. For the purposes of administering a claim, right? So what's going to happen is like you got to give all the information that's required in the portal. Then when a claim comes, you're like, okay, now we have to look at all the prior and the subsequent 2 weeks, every single day, how much was there a person, how many people were at the specific places of employment, and then how many positive tests were identified during that time period.
So, and I know you've touched on this before, but I still kind of get this question. Has this new law changed whether or not, well, has it changed the analysis under Honeywell about when you have to provide a claim form?
No, and we're going to talk about that in the next one. And this is going to lead, because we're out of time, it's going to lead me into the next, into advertising for the next one next week. We're going to talk more about 685, provision of a claim form, the obligation to provide. And we talked about this stuff in the past. We're going to lay it all out for the employer. But to answer your question, no. The existence of presumption does not change, in my opinion, the standard of knowledge under Honeywell to provide a claim form. But it's a complex issue, and we'll talk about it more in depth. But I think we went a little over, so I apologize. But man, there's just a lot of stuff here.
It really is. Thanks for having me.
Yeah, thanks for coming on, Pilar. I appreciate it. That's a good discussion for sure. I think we really have tried to flesh out all the issues that we could, and I'm sure there's a lot we're missing. But for what it's worth, and here's our information. You saw our contact information at the beginning. We're available for emails, phone calls, whatever you need. I mean, we're all working together trying to get this done, and that's what we do. And here we are. We appreciate you listening. And thank you, Pilar.
You're welcome. Thank you. Thanks, everyone.
Yeah, have a good day.